Hello everybody and welcome to History Bite number 41, dated September 16th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled, Unratified, Yet Still Pending U.S. Constitutional Amendments. As I explained to you in the previous History Bite about amending the U.S. Constitution, once an amendment has passed the Congress and is sent to the states for ratification, if that amendment does not contain a deadline or a sunset provision, then it remains as pending business before the state legislatures in perpetuity, forever, all right? Unless Congress withdraws it from consideration. So unless that amendment is ratified or withdrawn, it just sits out there like a piece of dead space equipment, like a broken satellite or something, all right, floating around the Earth, all right? You get the gist of it, all right? So currently, there are 4 proposed, unratified, yet still pending constitutional amendments that have been sitting out there for all time, doing absolutely nothing. Those 4 amendments are as follows: the Congressional Apportionment Amendment, the Titles of Nobility Amendment, the Corwin Amendment, and the Child Labor Amendment. All 4 of these proposed constitutional amendments have been sitting out there as pending business before the state legislatures for some years. In one case, more than 200 exact years. All right? So, let's go through each of them and we'll explore what they were intended to do and what possible effects they could have if ratified. Starting with the Congressional Apportionment Amendment. That amendment was designed to regulate the growth of the U.S. House of Representatives. It would have begun by saying there could be no more than 1 representative for every 30,000 state residents, proceeding to no more than 1 representative for every 50,000 state residents, per state, of course, okay? Had that amendment been ratified, then it is suggested that the House of Representatives would now have more than 6,000 members. A big difference from the 435 that we do have, okay? For the record, this amendment has been out there since 1789, all right? It was one of the original 12 proposed amendments to the U.S. Constitution, along with the others that we know as the Bill of Rights, all right? So this amendment, given the possible effects of it, is not likely to ever be ratified, all right? It is in the mindset of many that the House of Representatives is just right in its current size, and not many would be willing to have their taxes hiked to pay for House salaries with a House of 6,000 plus members. So that amendment is not likely to ever come into being. Number 2, the Titles of Nobility Amendment. That amendment has been sitting out there since 1810, all right? And specifically, what it would have done, its intended purpose rather, was to forbid Americans from accepting a title of nobility from any foreign ruler, such as a king, queen, prince, the whole lot, or prohibit any American without the consent of Congress from receiving any pension or emolument from a foreign ruler, under the penalty of losing your American citizenship and being prohibited from ever holding any office of trust or profit for the United States. And thus the effects of that amendment are quite simple if it was ratified. You know, if you are an American and you accepted a title of nobility from a foreign ruler, or without the consent of Congress, you accepted a pension or emolument of some kind from a foreign ruler, you would lose your American citizenship and be prohibited from holding any office of profit or trust under the United States. Okay? This amendment was intended to amplify the effects of the already existing provisions in the Constitution, which do not allow Americans to have any titles of nobility. Okay? Given what little public interest would be generated from such an amendment, it is not likely to ever be ratified, okay? Most Americans, frankly, could care less about titles of nobility, so there'd be no momentum for this amendment. Amendment number 3, the Corwin Amendment. This amendment has been sitting out there since 1861, unratified, thank goodness. The Corwin Amendment was designed to shield the institution of slavery from being abolished by way of constitutional amendment. Yes, if it had been adopted, it would have virtually made slavery an entrenched thing in America, unless each state were to abolish it individually. But the Corwin Amendment would have inhibited any federal efforts to enact a constitutional amendment to destroy slavery in the United States. Thank goodness, such amendment never was popular from the beginning, and to date has only been ratified by a few states, shamefully Maryland being one of them. Thankfully, we rescinded that ratification in 2014. If the Corwin Amendment were to be adopted, it would undoubtedly have some effects because its words stated that it would prohibit the federal government from interfering with the domestic institutions within the states. So if it were adopted, what domestic institutions it would be forbidden from touching remains an open question. But given the nefarious purposes of the Corwin Amendment, it is not likely to ever be adopted. Amendment number 4, the Child Labor Amendment. This amendment has been sitting out there since 1924, okay? It was enacted so that the Congress would have power, along with the states, to regulate child labor. At the time the amendment was proposed, the federal government had no such power. Indeed, it was the province of the states to regulate child labor, and previous federal efforts to do so had been ruled unconstitutional by the Supreme Court. So this amendment was passed to give the federal government that necessary authority, okay? If that amendment were adopted today, it would essentially be redundant, as by way of the Fair Labor Standards Act of 1938, a product of FDR's New Deal, the federal government does have the power to regulate child labor, thus for persons under the age of 18, okay? So the amendment would officially, give the federal government the power to regulate child labor, persons under age 18, along with the states, if it were adopted. But since they already have that power under the Fair Labor Standards Act, the amendment would essentially, like I said, be redundant, moot, having no real effect other than what already exists. So despite its noble purposes, very noble purposes indeed, it is not likely to ever be ratified. Okay? So let's recap real quick for these amendments that are still sitting out there that could be ratified at any time, all right, or withdrawn by the Congress at any time. First and foremost, the Congressional Apportionment Amendment, which has been sitting out there since 1789, would have regulated the growth of the U.S. House of Representatives. Number 2, the Titles of Nobility Amendment, that's been sitting out there since 1810, would have forbidden any American citizen from receiving a title of nobility from a foreign ruler, or without the consent of the Congress, receiving any pension or emolument from a foreign ruler, under penalty of losing your American citizenship and being forbidden from holding any office of profit or trust under the United States. All right? Amendment number 3, we have the Corwin Amendment. Okay? That amendment, quite simply, would have prohibited the federal government from adopting any amendments to abolish slavery in the United States. The amendment has been sitting out there since 1861, all right? It would have been impossible to abolish slavery by way of federal constitutional amendment. Slavery would have had to have been abolished individually, state by state. Good luck with that, all right? And last but not least, number 4, the Child Labor Amendment, which has been sitting out there since 1924, would have given the federal government the power to regulate child labor along with the states, okay? As they already have that power now under the Fair Labor Standards Act of 1938, the amendment is essentially a moot point. It would be redundant if it were adopted, and therefore is never likely to be adopted, okay? So those are the 4 proposed, unratified, yet still pending amendments to the U.S. Constitution. And they will remain that way unless they are ratified by the states or withdrawn by the Congress. from further consideration. Thank you so much for listening to this History Bite. I appreciate your attention. Please continue to listen to these History Bites, spread the knowledge, stay safe out there, and I'll talk to you at the next one. Take care.